Okay, so good day everyone. My name is Kurt A. Tutas and I'm going to present to you the Canon 6 Accountability of the proposed Code of Professional Responsibility and Accountability of the Philippines. Okay, so before we're going to discuss the different sections of this canon, let me introduce to you first what is the Canon 6 talks about. So this canon usually outlines ethical standards and accountability measures for legal professionals. It's essential for ensuring integrity and responsible conduct within the legal field. So by taking the lawyer's oath, a lawyer becomes a guardian of law and an administration of justice. So after taking the bar, it doesn't mean that you are already a lawyer. You have to sign different papers pa. You have to do oath taking, and then after the oath taking, you will become a guardian of the lawyer. And then as such, the lawyer shall observe the highest degree of morality, adhere to rigid standards of mental fitness, and faithful comply with the rules of the legal profession. So failure to honor this covenant or this agreement, it makes the lawyers unfit to continue in the practice of law and accountable to society, the courts, the legal profession, and the client. So there must be a sanctions of the lawyer if he failure to honor this covenant or agreements. So it depends on the investigating commissioner if what sanction must be awarded to that lawyer nga nag violate sa CPRA. Section 1, Nature of Disciplinary Proceedings Against Lawyers. Disciplinary proceedings against lawyers shall be confidential in character and summary in nature. Nothing less, the final order of the Supreme Court shall be published like its decision in other case. So, under this section, disciplinary proceedings against lawyer are confidential in character. In legal context, disciplinary proceedings against lawyers are typically designed to maintain the integrity of the legal profession and ensure that attorneys or lawyers adhere to ethical standards. In this section, it may outline the fundamental nature and objectives of this disciplinary process. So I have here 4 bullet forms that talks about discuss the importance of the section 1. So purpose of disciplinary proceedings, the purpose is to ensure that the integrity of legal profession and maintain public confidence in legal system. Grounds for disciplinary proceedings, common grounds includes professional misconduct, violation of ethical standards, dishonesty, fraud, or any behavior that undermines the trust and credibility of the legal profession. Next, fair and impartial proceedings. This is very important in all legal proceedings. Fair is very is included always. Lawyers facing disciplinary actions are typically entitled to a fair hearing, legal presentation, and opportunity to present their defense. The goal of this fair and impartial proceedings is to ensure a just and unbiased process. Next is confidentiality proceeding, which is I already discussed now. Section 1 may address the confidentiality of these proceedings to protect the privacy of those involved while ensuring a transparent process. Section 2, how instituted. Proceedings for the disbarment, suspension, or discipline of lawyers may be commenced only by the Supreme Court on its own initiative or upon filing of a verified complaints by the Board of Governors of the IBP or Integrated Bar of the Philippines, or by any person before the Supreme Court or the IBP. However, if a verified complaint against a government lawyer which seeks to discipline such lawyers as a member of the bar shall only be filed in the Supreme Court. So you can just only be filed if if you want to file a complaints against a government lawyer. So you just it ma-file lang nimo ni siya dito sa Supreme Court. A verified complaint filed with the Supreme Court may be referred to the IBP for investigation, report, and recommendation, except when filed directly by the IBP, in which case the verified complaint shall be referred to the Office of the Bar Confidant or such fact-finding body as may be designated. So, if the verified complaint is gifile mo siya directly to the Supreme Court, and then the Supreme Court will going to refer that file dito sa or that complaint dito sa IBP, because ang IBP for investigation, and the IBP will going to recommend what sanction nga best nga ihatag ato nga lawyer nga nag-violate. Section 3, Contents of the Complaint. The complaint shall be verified. Later on, we're going to discuss what is a verified complaint. It shall state clearly and concisely the acts or omissions complained of and shall be supported by judicial affidavits and such other documents in support thereof. Because if the complaint is not verified, it's just wasting of time, because all the statement that you have stated on your complaints are not clear and not concise. There is no initiative, evidence nga nakabutang, so that's why gina-prohibit ni siya dito sa court. Next, if the verified complaint is filed before the IBP, you will going to send 6 copies thereof shall be filed with the secretary of the IBP or the secretary of any of its chapters, and then this 2 nga maka-receive sa 6 copy will going to transmit the copy to the IBP Board of Governors. Section 4, List of Investigating Commissioners Qualifications. So I have put 4 key points here to discuss the Section 4. So, recommendation of lawyers. The IBP shall recommend to the Supreme Court kanang 150 lawyers in good standing and repute. And then next is proportional selection. This 150 lawyers came from 9 regions. Adjustment of investigating commissioners. The Supreme Court will be the one who will going to appoint if kinsa ato nga mga 150 lawyers ang mahimong investigating commissioners. But it depends on the caseload. Meaning, if daghan ang existing caseload, so maybe the Supreme Court will going to appoint the 150 lawyers. And if gamay lang ang existing caseload, maybe 50 of it, 150 of, half of it or 100 of it nga gi-recommend sa IBP ang i-appoint sa Supreme Court. Next is process on selecting investigating commissioners. The all approved investigating commissioners shall take an oath of office in the form prescribed by the IBP. A copy of investigating commissioners appointment and oath shall be transmitted to the Supreme Court. Section 5, Assignment by raffle of investigating commissioners. The IBP Board of Governors shall assign by raffle an investigating commissioners from among the lawyers approved by the Supreme Court in the list submitted by the IBP. So, pag nanay na-approve ng new investigating commissioners ang Supreme Court, of course, the IBP Board of Governors will be the one who will going to assign them kung unsang ilang task. And then, ang katong ilang task nga gi-assign sa Board of Governors is through raffle na siya. Through raffle. Or when special circumstances warrant, a panel of 3 investigating commissioners to investigate the complaint. The purpose of this process is to ensure a fair and impartial investigation of complaints within the legal profession. Kay ang trabaho man sa investigating commissioners is mag-investigate sa mga verified complaints. Section 6, Complaint Against a Government Lawyer. So, I already discussed this, Section 6, dito sa Section 2. When a complaint is filed against a government lawyer, the investigating commissioner shall determine within 5 calendar days from assignment per raffle whether the concerned agency, the Ombudsman, or the Supreme Court has jurisdiction, if the allegations in the complaint touch upon the lawyer's continuing obligations under the CPRA, if the allegations, assuming them to be true, make the lawyers unfit to practice the profession, then the investigating commissioner shall recommend that the complaint be dismissed. So, in this section, it outlines process for handling complaints against government lawyers. The aim is to efficiently and fairly address complaints against government lawyers. The process ensures a swift assessment of jurisdiction, and if the allegations are serious enough to potentially affect the lawyer's fitness to practice or involve ongoing obligations, the case proceeds. Otherwise, if the complaint lack of merit, then this regards a recommendation for dismissal is made. Section 7, Disqualification of Investigating Commissioners. An investigating commissioner shall, on his or her own initiative or upon motion, recuse from acting as such on the grounds of relationship within the fourth degree of consanguinity or by blood or affinity or by marriage with any of the parties or their counsel, professional legal relationship, pecuniary interest, or where he or she has acted as counsel for either party unless in the last instance the parties sign and enter upon record their written consent. So something like conflict of interest. Where an investigating commissioner does not disqualify himself or herself, dapat ang party is una mag-file og appropriate motion before ang IBP Board of Governors. The Integrated Bar of the Philippines Board of Governors shall resolve the motion within 5 calendar days. So that motion is dapat ma-resolve siya in then 5 calendar days. And then mag-base po sa vote if i-disqualified, mag-base sa vote dito kung kinsa ang present dito sa court kung i-disqualified bang isa ka lawyer or not. If ang vote is disqualified, then wala yung mabuhat. The final judgment of the court is dili na siya pwede i-retract. So final na gito siya. Section 8, Duties of Investigating Commissioners. The investigation commissioner shall investigate a complaint against any member of the integrated and thereafter submit a report embodying recommended action to the IBP Board of Governors within a total period not exceeding 180 calendar days from assignment per raffle. So, I've already discussed to you what is unsa ang duties sa isa ka investigating commissioner. So, they were the one who will going to investigate sa mga complaints, and then they also the one nga mag-recommend kung unsa nga sanction ang best fit sa isa ka lawyer nga nag-violate sa CPRA. And then they will just giving period of 180 calendar days from assignment by raffle para ma-investigate nila og tarong ang katong complaint. Section 9, Submissions Allowed Verification. The only submissions allowed are the complaint answer and position paper, which shall be verified. This means that they must be accompanied by a statement confirming the accuracy and truthfulness of the information contained in the respective document. A verification of non-forum shopping shall accompany the verified complaint. This certificate served as an assurance that the party filing the complaint has not submitted the same case in multiple forum or jurisdictions simultaneously. So ang purpose ani para naa sila assurance nga dili daghan ang imong gi-file, dili isa ra ka court ang imong gi-filean ani nga case or ani nga complaint kay gina-prohibit man gud ni siya. So dapat na ay certificate of non-forum shopping. Next is an unverified complaint answer position paper shall not be considered. Kay it's just wasting of time. Kay all the statements that you have stated in your complaint is not clear and not concise. So sayang lang ang oras. Section 10, Prohibited Submissions. These are the following submissions that are prohibited sa court. Motion to dismiss the complaint or petition except on the ground of lack of jurisdiction, litis pedentia, or res judicata. So this lack of jurisdiction improper service of process, or you're not following the process. And then litis pedentia, it means the same case is already pending. You are already filed a case, same case, and then pending pa siya sa court, so it's gina-prohibit na siya. And then next is res judicata, or nanay, you already file a case, same case, and then na siya final judgment, so that you're not allowed to file another one in the same case. Motion for bill of particulars, lacking a specific details or statement of the facts, claims, or defense involved in the case. A motion to reopen for new trial. A motion to reopen or for a new trial is typically filed after a court has rendered a judgment. Petition for relief from judgment is filed to request the court to set aside or modify a judgment previously entered. Supplemental pleadings or additional documents filed by a party to provide further information or address new developments in the case, because na tendency nga ma-change nimo ang dagan sa hearing. And then the last one, motion for reconsideration of judgment on the merits. So in short, it is to challenge the final decisions of the court. Section 11, lack of prima facie, showing of liability, outright dismissal. Within 15 calendar days from assignment per raffle, if the investigating commissioner finds no prima facie or no initial evidence showing of liability, the investigator shall recommend the outright dismissal of the complaint to the Supreme Court. So, meaning, kanang they will going to dismiss the case without any further proceedings. Diretso na nila og dismiss. The Supreme Court may adopt the recommendation and dismiss their complaint outright. Otherwise, it shall direct the investigator to conduct further proceedings. Section 12, effect of death of lawyer and administrative disciplinary cases. Disciplinary proceedings may not be instituted against a lawyer who has died if such proceedings have been instituted notwithstanding the lawyer's death. The administrative case against said lawyer shall be dismissed. So, in short, if namatay ng isa ka lawyer nga na ay gifilan siya og complaint, pag namatay na siya, and then that case is ma-close na siya or ma-dismissed. Section 13, issuance of summons. Within 15 calendar days from assignment per raffle, the investigating commissioner shall issue the required summons, attaching thereto a copy of the verified complaint and supporting documents, if any. The summons shall require the respondent to file a verified answer. So, the investigating commissioner shall mag-required siya og summon dito sa respondent, which is naka-attach dito ang theoretic o copy of verified complaint and supporting documents para ma-aware ka unsa ang unsa imong mga complaints o ngano gi-invite ka sa court nga mag-adto. And then that summon is required po nga ang isa ka respondent nga gi-sendan sa summon is maghatag og verified answer. Section 14, verified answer. The answer shall be verified and filed within 30 calendar days from the receipt of their summons. The verified answer shall be accompanied by judicial affidavits and such other documents in supporting thereof. So, after ma-receive ni mong summons, hatagan lang ka og 30 days para mag-file ka sa imong verified answer. So, that verified answer nga imong gi-file is dapat it accompanied by judicial affidavits and such other documents in support thereof. Section 15, dismissal after answer. If the verified answer shows to the satisfaction of the investigator that the complaint is not meritorious, the investigating commissioner shall recommend to the Supreme Court the dismissal of the complaint. Otherwise, it shall direct the investigating commissioner to conduct further proceedings. So, naghatag na o nag-respond na ang respondent sa iyang verified answer if the investigators or gakasatisfied sila that there is no meritorious, and then they will going to recommend to the Supreme Court nga i-dismiss ang complaint. Otherwise, it shall direct the investigating commissioner to conduct further proceedings kung dili sila satisfied sa verified answer nga there is no complaint is not meritorious. Section 16, irrelevance of distance, settlement, compromise, restitution, withdrawal, or failure to prosecute. So, if ang isa ka respondent is present din, irrelevance of distance, layo siya, settlements na agreement, compromise, restitution, withdrawal, or failure to prosecute, ang proceeding is dapat i-continue gyapon siya. Dapat dili siya ma-interrupt just because of this mga reasons. Section 17, Counsel de Officio. The IBP Board of Governors shall appoint a suitable member of the integrated bar as counsel de officio to assist the complainant or the respondent during the investigation in case of need for such assistance. So, kanang mga PAW. Purpose of this is to provide legal assistance and representation to either the complainant or the respondent during the investigating if there is a need of such assistant lang naman. This section outlines the provision of legal counsel known as counsel de officio. Section 18, investigation. Upon joinder of issues or upon failure of the respondent to answer, the investigation shall proceed with the investigation of the case with dispatch. However, if despite reasonable notice, the respondent fails to file an answer or appear in the investigation, shall proceed ex parte. Ex parte meaning the investigation will proceed without the participation of the respondent. The respondent shall be given full opportunity to defend and be heard by himself or herself or counsel to present witnesses para fair pud ang proceedings. The investigator shall have the power to issue subpoena, to administer oaths. Subpoena is a legal documents issued by the courts or other legal authority that commands the individual to appear, and they can also administer oaths to ensure the truthfulness of the information. Section 19, indirect contempt, pertains to indirect contempt, which refers to disrespectful or disruptive behavior that occurs outside the immediate presence of the court. It involves actions that undermine the authority or proceedings of court, such as disobeying orders, and may lead to legal consequences. So this section outlines the consequences for willful failure to comply with a subpoena or lawful order issued by the investigating commissioners. Section 20, submission of preliminary conference briefs. Immediately upon receipt of the verified answer, the investigating commissioner shall send a notice to the parties and counsels to simultaneously file within a non-extendable period of 10 calendar days from receipt of the notice their respective preliminary conference briefs, which shall contain the following. So these are the contents of a conference brief. We have admissions, stipulation of facts, definition of issues, judicial affidavits, marked exhibits, and so on. Such other matters as may aid in the prompt disposition of the action. So those are the contents of a conference briefs. Section 21, preliminary conference order, position papers. Within 10 calendar days from receipt of the preliminary conference briefs, the investigating commissioner shall issue a preliminary conference order on the basis of such briefs submitted by the parties and counsels, summarizing the stipulated facts, issues, and marked exhibits. The investigating commissioner shall further direct the parties to submit their verified position papers within a non-extendable period of 10 calendar days from receipt of the preliminary conference order. So the purpose of the preliminary conference order is to formalize the agreement, admissions, and evidence presented in the PCB. Section 22, clarificatory hearing. Within 10 calendar days from receipt of the last position paper, the investigating commissioner shall determine whether there is a need to conduct a hearing to clarify factual issues and confront. So it depends on the investigating commissioners. If deemed necessary, the investigating commissioner shall set a hearing within 15 calendar days from such determination and identify the factual issues to be made subject of the hearing. The investigating commissioners may subpoena any witness to appear at the hearing to answer clarificatory questions. So, pwede sila mag-invite to answer clarificatory questions. The clarificatory hearing may be done in person. Section 23, Minutes of Proceedings. The proceedings before the IBP shall be recorded. Pwede siya written o pwede po siya through device. Basta kay recorded siya. Section 24, Non-Appearance of Parties. Non-appearance at the clarificatory hearing shall be deemed a waiver of the right to participate therein. So, their absence should not automatically be seen as them giving up or waiving their right to participate. Section 25, Issuance of Report and Recommendation by the Investigating Commissioners. With no clarificatory hearing, where no clarificatory hearing was called, investigating commissioners are required render a report and recommendation and submit the same to the IBP Board of Governors. This document or recommendation and submit the same to the IBP Board of Governors. With clarificatory hearing, where a clarificatory hearing was called, investigating commissioners are required to submit the said report and recommendation within a non-extendable period of 30 days from the termination of the hearing. So, it mandates the commissioners to produce a comprehensive report and recommendation based on the investigation conducted. This reference serves as a formal document of the findings and suggestions which may be used for further action or decision-making processes. These are the accompaniments or the attachments. First is the duly certificate transcript of stenographic note or TSN. In lieu of the said TSN, audio recording, if any, or investigating commissioner's personal notes duly signed. So, it should be nakasigned siya para sure. Section 26, Submission of Resolution by the Board of Governors. The IBP Board of Governors shall have a non-extendable period of 90 calendar days from receipt of the report and recommendation of the investigating commissioner, within which to submit to the Supreme Court its resolution adopting, modifying, or disapproving such report and recommendation. Upon receipt of the report and recommendation from the investigating commissioner, the IBP Board of Governors are required to act on its required to act on it by submitting the resolution either. Section 27, Dispositions. Dispositions may be taken in accordance with the Rule of Civil Procedure as amended with leave of investigation commissioner. With leave from the investigating commissioners, disposition may be restored to in accordance with the Rule of Civil Procedure as amended. So, in short, it refers to the final resolution or judgment reached in the case. Section 28, Filing and Service. So these are the mode of filing and service of papers under the CPRA. So first, personally, registered mail, accredited courier, electronic mail, and other electronic means, or as provided for an international conventions to which the Philippines is party. Proof of filing and service shall be submitted in accordance with the Rule of Civil Procedures as amended. This is, of course, para na ay proof nga nag-file ka o nagsubmit ka